Université Paris 1, Panthéon-Sorbonne. And she has lectured at the Hague Academy of International Law. In 2011, she was elected as an associate member of the Institut des Droits Internationaux. From 2011 to 2014, she sat as judge ad hoc in the case concerning whaling in the Antarctic, Australia versus Japan, New Zealand intervening at our call. Mrs. Charlesworth is the author of many publications in the field of public international law, and she serves on the editorial board of numerous international legal journals. I shall now invite Mrs. Charlesworth to make the solemn declaration prescribed by the statute, and I request all those present to rise. Mrs. Charlesworth. Mrs. Charlesworth, could you please turn on your microphone first? Ms. Charlesworth, I don't think that we can hear you. Can you try again now? No, I don't think we can hear you, Ms. Charlesworth. Can you turn on your microphone? Mrs. Charlesworth, please try again now. No, we can't hear you. I think we can all sit down and wait for a minute for Mrs. Charlesworth to try again, and maybe the technicians can help her.
Hello, is that working?
Yes, now. Please all rise. Ms. Charlesworth, you can make your solemn declaration now.
Thank you, Mr. President. I solemnly declare that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially, and conscientiously.
I thank you. Please be seated. I take note of the solemn declaration made by Mrs. Charlesworth and declare her duly installed as judge ad hoc in the case concerning the arbitral award of 3 October 1899, Guyana versus Venezuela. After ascertaining the views of the parties, the court decided, pursuant to Article 53, paragraph 2 of its rules, that copies of the Memorial of Guyana and documents annexed thereto would be made accessible to the public on the opening of the oral proceedings. The court also decided, in light of the absence of an objection from Venezuela, that Venezuela's memorandum submitted on 28 November 2019 would be made public at the same time. In accordance with the court's practice, these documents and their annexes will be put on the court's website from today. I would now like to welcome the delegation of Guyana to this hearing. The delegation of Guyana will be participating in the hearing by video link. I note the remote attendance at the hearing of the agent, co-agent, counsel, and advocates of Guyana. In accordance with the arrangements for the organization of the proceedings which have been decided by the court, and in light of Venezuela's decision not to attend the hearing, Guyana now has 3 hours to present its oral argument. In this sitting, Guyana may, if required, avail itself of a short extension beyond 5 p.m. in view of the time taken up by the opening part of this oral proceedings. I now give the floor to the co-agent of Guyana, His Excellency Sir Sridhar Rampal. Sir Sridhar Rampal, you have the floor.
Mr. President, distinguished members of the court, good day. Guyana commends, acclaims, and thanks this honorable court on this virtual hearing, which proclaims to the world a message from the court that COVID-19 notwithstanding, this fountain of global justice continues to spring forth. It is a privilege to be the first to address you as the court breaks new procedural ground. I and my colleagues who appear before you on behalf of the state of Guyana shall remain conscious of this element of novelty throughout the hearing, and we shall be ready to adapt to it as the court deems fit. No word of introduction from me can be adequate, Mr. President and eminent judges, without impressing at the very outset the singular importance of this case to the people of Guyana, whose collective patrimony is at the very center of this hearing, and who are united in defense of their sovereignty and the territorial integrity of their homeland. Guyana's official and representative delegation has been notified to the court, especially joining from the Ministry of Foreign Affairs in Georgetown are our agent, Honorable Carl Greenwich, our co-agent, Ambassador Audrey Waddle, Opposition Representative Ms. Gail Teixeira, former Foreign Minister Rashid Jackson, and Ambassadors Cedric Joseph and Elizabeth Harper. Many, many other Guyanese are with us virtually today, watching these proceedings, mindful of their significance for the future of our Guyanese nation. Among them, prominently, our first people, whose birthright is inviolable. I myself was born in what was the colony of British Guyana on the 3rd of October, 1928. 3 decades exactly. On that exact date, on the 3rd of October, 1899, the land boundaries of my birthplace had been affirmed, definitively settled in Paris by the award of an international tribunal of high distinction. Upon Guyana's independence in 1966, I had the honor to serve as its first Attorney General, and so to draft a constitution, the first words of which were that Guyana should be a sovereign democratic state. And that first article of the Constitution of the newly independent Guyana went on to say, the territory of Guyana shall comprise all the areas that immediately before the 26th of May 1966 were comprised in the former colony of British Guyana. As Guyana's co-agent in these proceedings, I consider myself to have a rather special responsibility. Let me try to convey succinctly, in these very words, how and why we are here today. That day in Paris, at the end of the 19th century, is now a long time away. 120 years have passed since international law spoke. During that time, colonization in British Guyana came to an end, and Guyana has now enjoyed more than 50 years of independence. That might suggest a rather ordered past, given that the boundary was definitively settled a long time ago. But that would be wrong. In a word, we are here because, contrary to international law and to the binding award of 1899, the Bolivarian Republic of Venezuela, our neighbor to the west, has cultivated a nationalist passion to disavow that day in Paris and lay claim to almost 3/4 of Guyana. It was not always so. The arbitral proceeding in Paris was, after all, instigated at the behest of Venezuela. And Venezuela enjoyed and continues to enjoy the gains brought to them by the arbitral award. Yet, the process that brings us here is rooted in Venezuela's repudiation of that award. Repudiation more than 6 decades after it was handed down, at a time that seemed propitious to it, the very eve of Guyana's independence in the 1960s. Paris, 1899, was the very fulfillment of Venezuela's early and quite understandable wish that the border between themselves and Britain's colony of British Guyana should not be left to negotiation with the imperial power, but should be determined by international arbitration. In this, they were supported by the United States, supported to the extent of threats from Washington of war with Britain if the matter was not settled. Britain eventually concurred. By the Treaty of Washington in 1897, brokered by the United States and concluded between Britain and Venezuela, Venezuela would have